Today on Bench Briefs, we're looking at a fascinating case from the Supreme Court of Canada that explores the intersection of police discipline and criminal law, R. v. Wigglesworth. This 1987 decision delves into whether disciplinary proceedings against a police officer can be considered a criminal prosecution and what that means for protections against double jeopardy under the Charter. Let's start with the story itself. Wigglesworth was a police officer who found himself in hot water for conduct deemed unbecoming of a police officer. Because of this, he faced disciplinary proceedings under the Police Act, which is essentially a set of rules governing police behavior and conduct. At the same time, he was also charged with a criminal offense related to the exact same conduct. So two separate processes were happening simultaneously. One disciplinary, one criminal. This raised a big legal question. If the Police Act disciplinary process is considered a criminal prosecution, then going through both the disciplinary hearing and the criminal trial for the same conduct could be seen as punishing someone twice for the same offense. That's what the Charter of Rights and Freedoms seeks to protect against in Section 11H, which says that a person can't be tried or punished more than once for the same offense. This protection is commonly known as protection against double jeopardy. So the Supreme Court had two main issues to decide. First, are disciplinary proceedings under the Police Act criminal in nature? In other words, do they count as criminal prosecutions for the purposes of the Charter? Second, if they are criminal, does having both disciplinary and criminal proceedings for the same conduct violate the protection against double jeopardy? To answer these questions, the court looked closely at the nature and purpose of the disciplinary proceedings. Unlike criminal prosecution, which aims at punishing wrongdoing to uphold public order and justice, disciplinary hearings are designed to maintain professional standards within the police force. They focus on internal accountability rather than criminal guilt or innocence. The court emphasized that not all penalties or proceedings that impose sanctions are criminal. For something to be considered a criminal prosecution, it has to involve a punishment that is penal in nature, and the process must be intended to punish wrongdoing in a criminal sense. Disciplinary proceedings, while they can lead to penalties like suspension or dismissal, are fundamentally about regulating professional conduct, not criminal punishment. In Wigglesworth's case, the court concluded that the Police Act disciplinary proceedings were not criminal prosecutions. Therefore, facing both disciplinary action and criminal charges did not amount to double jeopardy under Section 1111H of the Charter. The two processes serve different purposes and operate independently. Why does this case matter? R. v. Wigglesworth sets an important precedent in Canadian law by clarifying the distinction between criminal proceedings and disciplinary actions in professional contexts. This distinction is crucial because it helps define the scope of constitutional protections like the right against double jeopardy. Without this clarity, professionals like police officers, doctors, or lawyers could be unfairly shielded from internal discipline just because they face criminal charges, or conversely, they could be subjected to multiple punishments for the same conduct. The decision also reassures the public that police misconduct can be addressed in multiple ways, through criminal law when appropriate, and through internal discipline to maintain trust and integrity in the police force. It balances individual rights with the need for effective professional regulation. Thanks for listening to this episode of Bench Briefs. Join us next time as we explore another key case shaping Canadian law. Until then, take care.